Welcome, everybody. I'm going to give you just a few more seconds as everybody comes in, but we're going to start in just a few seconds. All right. Thank you, everybody. I'd like to welcome you all to a fantastic program that I have been very excited about. First of all, I'd like to thank and welcome again Judge Vanessa Zecker. And we all know Judge Zecker, who is now with JAMS, but Judge Zecker was sworn in as a judge back in 2011. She had been an attorney for 23 years before that, and we all know Judge Zecker as a family law attorney, but she had run the criminal division for a very long time before joining the family law bench. And then we've missed her on the family law bench, but we welcome her wonderfully with JAMS. And thank you very much for the program that she does do for us over at JAMS. Also like to welcome, thank you, Jim Hoover, who graduated from Santa Clara Law School, summa cum laude.
Oh
And
God, you're reading my bio?
I know you didn't. I had to put it together myself, Jim. Of course you didn't, but I know you very well. Also, I know you from your dad. So
Yep.
you did graduate summa cum laude in 2001, and also you ranked fourth in class over 200 students, receiving your top of the class in the Cali Award. You have experience and expertise, and you also serve as a mediator. And in May 2013, you became a certified family law specialist. And also, you were honored by the Board of Legal Specialization that approximately only 10% of the family law attorneys received back in that year. We'd also like to welcome David Luca, who has been licensed as an attorney since 2005, and he's been involved in every type of family law issue. He's litigated restraining orders, custody and visitation, spousal support, property issues, pre and post nuptials, reimbursement claims. He's participated in trials covering all issues in family court. He served as a volunteer arbitrator and mediator and a judge pro tem. With that, we are going to ask you, first of all, that to hold your questions to the end. We may or may not have time. If we don't, then hold your questions because we are having the practicum portion of this presentation Thursday at JAMS, and you can ask all your questions then, and we're going to have alcohol and special treats. So please join us at JAMS on Thursday night starting at 5:30 for networking and a really good time to continue this presentation. And we will have materials, you always ask us, we will have materials that will be distributed after today's presentation. And with that, I am going to turn it over to Judge Zecker.
Well, thank you, David and Jim. I'm going to turn it over to you. I will ask questions as they may come up, if that's okay with you. And we're thrilled to have you. Thank you for saying yes.
Right on. Thanks, everyone. So welcome, good afternoon to the Bar Association's presentation of Law in Motion, the Rules and Reality in Family Law Practice. My name is Jim. I am a family law attorney, and I'm a presenter. But enough about me. Dave, why don't you introduce yourself?
Good afternoon, everyone. My name is Dave Luca. I've been doing family law for longer than I'd like to admit. I enjoy doing it. I'm really excited to be presenting with Mr. Hoover today. I think between the two of us, we have 40 some odd years of experience, so we might drop a pearl or two today. That's the hope.
Right on. All right, so we're going to dive into a street level and ivory tower view of law in motion, both with respect to the rules, with pre-filing, with filing, with pre-hearing, hearing, and post-hearing. With the following caveat and disclaimer, we don't speak for the judiciary. We only speak for ourselves. When we have won, we have lost, but we've always learned in court. And certainly if you want to learn more, feel free, please come to the practicum at JAMS. It will be a great time. We'll have a good time. All right, so let's start off without further ado with respect to the rules of law in motion. Number one, read them. What are those rules? Well, we've got the California Family Code, we got the CCP, we have the California Rules of Court, we got the local rules, we We've got the rules of professional conduct, and then we also have the Santa Clara County Bar Association rules. But notably, I want us to focus today on the issue of what is evidence, what is live testimony, and what's an evidentiary hearing. Because if you've never handled a hearing or a motion, you can read the rules behind me, and it says Family Code Section 217, the court shall receive live testimony. Okay, unless there's good cause. And then you look at California Rules of Court 5.113, which states that the court shall receive live testimony, whether it's parties or others, absent good cause. Okay, all right, so you're going to your first hearing, you're thinking with these code sections, you're going to have live testimony. Well, all of you think about how many times have you presented live testimony at a hearing? Not very often. At least I don't. Maybe I'm doing something wrong, but I'm not getting live testimony in. I show up, I start arguing, and hopefully, and yes, the court has read the pleadings. Now, why is that the case? Well, California Rules of Court 5.111 states that the court may consider, receive as evidence one's declaration, the party's declaration. And Dave will get into that, but that highlights the importance of your filings, how important it is to what's in your pleadings, because the judiciary does read these pleadings, and it's not often you always get an evidentiary hearing. So what's the reality? You can show up to a hearing, you can cite these code sections, and the court likely would say the following: Mr. Hoover, if you want an evidentiary hearing, you may not have it today. I may not even grant it to you, or if I do, it may be in the weeks or months to come. So that's the reality you have to deal with, is how good and how persuasive are my pleadings, and what am I able to accomplish in court? You got to read that room in the court. If the judge is going your way, submit it. If the judge isn't going your way, maybe you want to have that evidentiary hearing. You also want to take a look at the California Code of Civil Procedure. Has a lot of rules in there with respect to what applies in family court. And of course, Family Code Section 210 states that practice and procedure in the civil code also applies to the family courts. You want to take a look at.
Jim, may I ask a question? And I will be interrupting. I already told both
Please
of you
do.
that.
I expect it.
Thank you. Do you file a 217 notice in every law and motion matter? No.
You're not required to, because most of law and motion matters, it's just the parties. And if it's just the parties, you're not required to do so.
Thank you. But if you have any third party, any potential for third party in every case.
Subsection C, you're required to do so. And I just found out there's a digital counsel form to do it. I've never used the digital counsel form. It's 312 or so. I probably have it wrong, but I can say it convincingly. So it's one of those code sections. It's in our pamphlets. It's really important to review the local rules. You should do it once a year. I do, to learn and to remind myself as to what's allowed and what's not allowed in law and motion, to review the California Rules of Professional Conduct and our own county's rules, which states in its preamble that we go above and beyond the duties and ethics as required in our state because we want to, quote, distinguish ourselves from other jurisdictions. All right, let's now move into the pre-filing. What is law and motion in pre-filing? Now, pre-filing is you have a client comes to you and you need to address what exactly are we going to do. Well, at that point, as an attorney, presumably I'm speaking to quite a few attorneys, your duty is, as I consider it, threefold: education, advocacy, acting in your client's best interest. Education, advocacy, and acting in your client's best interest. So at that point, you're not before a judge, you're in your office, and you are educating your client as to their case. First thing I tell my clients is if they're going through a divorce or a process in the family courts, it's a process by which two main things occur. Number one, your marital status reverts to single if it's a divorce. And number two, your rights and your responsibilities in the 5 main areas of family law. Sure, there are more, but the way I look at it is there's domestic violence, custody and timeshare of children, assets and debts, spousal support, child support, and everything else. Each one of those fundamental issues in family law requires its own type of review with respect to law and motion. And I walk them through what, in an ideal case, is there a law in motion? No, there's not. Again, taking the example of a divorce, if the parties going through divorce, a perfect divorce, if there's such a thing, is that one party files the petition, one files a response, or there's a joint petition and response, joint petition that is. Then we're in what I call the 4D stage: due diligence, discovery, and disclosures on those 5 fundamental issues in family law, if they exist. The parties exchange their declarations and disclosures. They draft up a settlement conference, a term sheet, marital settlement agreement. You slap the divorce decree on and you provide it to the court. And you're done. That's it. That's the ideal divorce. There's no law in motion there. Not required. Now, what is law in motion then? Law in motion is if you need temporary relief pending the conclusion of the case. If you need relief in one of those 5 main areas or other areas, you may file a request to go before the court on a temporary basis to address whether it's domestic violence, whether it's custody and timeshare, spousal support, child support, asset division, reimbursement claims, and anything else. So at that point, I'm still in the pre-filing stage. I'm now, how do we prove to create that perfect declaration that Dave Luca is going to be talking about? So I work through those 4 Ds: due diligence, discovery, disclosures. You get that information because, again, your declaration is of so much importance, because when you appear in court, it's likely there's not going to be live testimony by the parties or otherwise. It can happen, but the reality is it may not. So I tell all of my colleagues with whom I work that we've done very well going to law school and passing the bar. Family law is no different. You see a fact pattern, you apply any one of those main areas, the 12 factors for DV, custody, support, whatnot. You apply it. I'll be doing it today on custody and timeshare if we get to it. And then you draft the perfect declaration. I also, before I turn it over to Dave, wanted to talk about setting expectations with respect to the issue of what is law in motion in court. Remember, we need to have bedside manner with our clients with respect to what is law in motion. To them, anytime that there's a court matter, it's the trial of the century. So it's making sure that you sit there and that you meet them where they're at as to what is that process like. My dad once told me, go down a week beforehand and just watch. He's not wrong. Sometimes I tell my clients, go down there and watch. But I educate them as to what's going to be happening through that process. It's not just your matter. It's going to be probably 10 or 12 or 15 other matters. We're only going to get 15 minutes to a half an hour each side. What to wear, where to park, and all the above. So that when they arrive, there's a sense of confidence that they have, that we have, that when we're right before we say, good afternoon, Your Honor, so-and-so for such and such, they already look around thinking, I was already told by Hoover this was kind of going to happen this way. Then, of course, the meeting conferring with counsel. But before we get to that, Dave, I think I hit it all. I'm going to ask you, Judge Zecker, any pop quizzes on this before I turn it over to Dave on the actual filing?
Not yet. Go ahead, Dave.
Okay.
So I'm going to kind of touch on what Jim mentioned about client expectations. I've learned this the hard way, that failure to set reasonable expectations with your client is going to cause conflict between the attorney and client in the future. And law in motion seems to be one of the areas where that is most likely to occur. When people come into your office, unless they've got a frequent flyer card for divorce court, this is likely their first time. They don't know what to expect. And their expectations up until they've met with their lawyer have been shaped by what they saw on TV, their friend Billy Bob who got a divorce and what happened in his case, what neighbors have told them. And 9 times out of 10, their expectations are all out of whack. And I think that having that conversation before you get to the filing stage of any motion you decide you need to file in the case is a very, very critical, important step for the attorney-client relationship. But let's assume that you've done your due diligence, that you have managed your client's expectations, and it is time to file a motion. Your meet and confer efforts have failed. You have an opposing counsel who is unreasonable, and you have no other choice but to file a motion. What do you need? Evidence. It's pretty important to have in a motion. You need something for your fact finder to review to support the relief that you are requesting. Evidence can take the form of a written declaration, could be exhibits, could be testimony from third parties. When you're starting to craft your motion, and most specifically your declaration, I always take a moment, look at all the information I've been provided from my client, and before I put pen to paper, I go, who is my audience? What judge is this going to go to? What does this judge like? What does this judge not like? What are my experiences with this judge? I think that that will help shape your declaration in a way that is reader friendly. You want your fact finder to go, oh, this is a motion from Dave Luca. I can't wait to read this thing. These are so good. You do not want your fact finder to go, oh, this is Mr. Hoover's office. It's 9,000 pages of dribble I don't want to read, because then you've lost your audience. And then it's
High
going to be
quality dribble.
impossible for you to get what you're asking for. Declarations, they don't need to be terribly long. Remember, we're doing a law and motion case, right? 10 pages or less is what the court rule says. Judicial counsel forms and exhibits don't count, but 10 pages. Most people can write the entire history of their marriage in 10 pages. So you definitely don't need it on a little segment of a divorce case for your fact finder to have to sort through. Because you only get 10 pages, it's usually advisable to put what you want first. Just separate 3 or 4 paragraphs. They can be a couple sentences each. This is what I'm asking the court to order, and this is the brief reason or reasons why I'm asking the court to order it. All the other factual background can come in later in a declaration, but the highlight reel, as Jim calls it, I think is extremely important in a declaration because it puts everything front and center for your judge to look at. I've been told by judges, sometimes they get to the highlight reel, they understand what's being asked for, and they go, I stopped reading. I'll figure out the rest later. If you don't have that highlight reel, they're never going to get to that point to begin with. When you are making your declaration and all the facts start coming in about what happened or what somebody's claiming or what their contentions are, be very careful to separate out facts from argument. I see a lot of declarations that are, 50 to 60% argument, that you're trying to have to sort through the paragraphs to find, well, where are the facts that are supporting this argument? Your fact finder doesn't need that. That's why, you pay Jim the big bucks to show up to court and yell like hell at everybody who's there about what he wants and why. Don't put that in declaration. Keep your declarations clean and crisp. Here are the facts you need to know, Judge, to make the decision I'm asking you to make. When you have third parties, third-party declarations are just like any other declaration you'd have for your own client. I tend to shy away from putting too much information in my third-party declarations. I like to leave something to have my client or to have the third party testify to in court. And I don't want to put everything out there so the opposing attorney can just rifle through it for a great cross-examination. Leave some things to the imagination if you can. Exhibits. Don't use too many. Don't use too many. I can't stress that enough. Attaching every order that was ever issued in the case before the hearing date isn't helpful for your fact finder. Attaching a bunch of old pleadings that may have been filed in the case, generally not helpful to your fact finder. If you are going to attach exhibits, be judicious with them. Understand what is important for what you want to get out of this law and motion hearing and limit it to those exhibits. You can ask the court to take judicial notice of the entire case file if you think that's appropriate at your juncture in the case. But don't attach all that stuff. It angers the clerks. The judges tend to think, why am I reading 500 pages of material for a hearing that's going to be 15 minutes? Try and keep it judicious, like I said. Jim's specialty is meeting and conferring before you actually send the motion in to be filed. There's nothing wrong with that. It's encouraged. If you've gathered all of your evidence, gathered your declaration, got your exhibits ready to go, got your highlight reel all polished, pick up the phone. Go, hey, so-and-so, I got to file a motion for X, Y, and Z. Can we talk about it? Most times you will find that while you might not be able to settle everything, you might be able to get on track with settlement, might be able to put some wheels in motion that can lead to the settlement of your overall law and motion matter before you have to step foot in court. Judges like it, clients like it, provides them some certainty about what's going to happen. Local rules require it, so pick up the phone. With that, I'm going to turn it over to Jim unless Judge Zecker has any questions.
I'm going to make I have 2 comments. First of all, the highlight reel, as you phrase it, very, very helpful. Judges are busy. Often we're looking for just a synopsis of what you want. It helps us with our notes. So I endorse that wholeheartedly. With respect to taking judicial notice of the entire court file, that puts us in a difficult position because then we have to review everything in the court file. So the only thing I would say, I think you just threw that out. And so I think the only thing that I would say is to be judicious in what you ask your judge to take judicial notice of, and to be mindful of the judicial notice requirements. Okay, Jim, thank you.
Sure. Thank you,
And
Judge.
Jim, in your, I think, are you going to move to like the hearing sort of?
I'm
Because
going
there's
to still talk a bit about the filing process before we get into the hearing. I'll turn it over to Luca for the hearing.
Okay, David, there is a question. So just as part of yours, do you mark exhibits? Okay, so if you could talk about that, do you mark exhibits at the time of the hearing? Okay, yeah. All right, Jim, go ahead.
Quick answer is we know it depends upon the judge.
Okay.
Really, it depends upon the county, depends upon the judge.
Okay.
This seminar was already so worth it for me to hear you both talk about the highlight reel. A lot of my colleagues who may be on this call know that I sit there and say, where's the highlight reel? You have to assume the judge has like 90 seconds reviewing this. And there might be a judge who's on this seminar right now who may recall a time when he or she was reviewing some pleadings, and on like the 7th or 8th page was a reference to some fairly severe domestic violence, to which he or she responded, way to bury the lead on page 7 or 8. So you do want to have a quick intro. You want your requests, and you want that highlight reel. If like you had 60 seconds to present to a judge, very important. This goes back to California Rules of Court 5.111, which states that any declaration must be based upon personal knowledge and also admissible evidence. I neglected to state, if you don't object to it in writing, good cause in court, but in writing, the court may consider it. I can be considered my practice perhaps sloppy. I rarely do the objections, maybe because I'm just in the courts in and out all the time, and I see the courts don't really accept it as complete evidence in the declaration. But I do know certain counsel will make those objections to a declaration based upon the fact that California Rules of Court, and also that it contains hearsay and whatnot. I also, on the exhibits, sometimes I bring copies in, particularly when it's issues, say, spousal support, child support. I like to bring in a couple of copies here that might be notable, a couple of the extra income and expense declarations or whatnot. Of course, the ex-spouse and the computer printouts, those are going to be good to have extra copies for the court. Okay.
So Jim, may I ask a question?
Yes.
Do you believe that judges should review the exhibits prior to the hearing?
Yes, I expect that they do. But yes, I believe they should be reviewing the exhibits. Again, it's a symbiotic relationship insofar that we have to take care of our judiciary and not overload them with their limited resources. In that, as long as we only have a few exhibits and they're very pertinent, not historical record and procedural history, but if it's support issue, here are the redacted tax returns, certain portions of the redacted tax returns. Here's the MSOL done by an expert. Here is their latest pay stub. I expect the court to review that beforehand. Of that, I will have copies though. All right, let's move into some other areas that may be a little more boring than what Luca was talking about, like timing, et cetera. You know, you have to serve under the CCP 1005, serve your motion or your request for order 16 court days beforehand. Hey, good news. We're not getting these back. And I mean, the lead time is like 2.5 months for hearings, often with the court. So you got plenty of time. My advice is, and it goes to the rules of professional conduct and the Bar Association rules, serve it right away. Right away. Unless there's some reason that you shouldn't, which then perhaps that should have been next parte, but I'll get into that in a moment. Why hide the ball? Provide, when I get the motion or the request from the other side and I see I received it 16 court days before a hearing, thanks, like Lucas' look on his face, I feel the same way. I'm like, you didn't have to do that. There's no reason to do that. You don't want that to be done on you. So just serve it right away when you receive it. Responsive pleadings, 9 court days beforehand. Reply declarations, 5 days beforehand. Objections, I did mention before, doing objections. Part of me sees it as from the ivory tower, you're required to do so. Street level, it seems like make work. I feel like that there's some understanding that when you go to court and you say, Your Honor, their declaration is replete with hearsay and it lacks foundation, etc. I haven't seen a court say, well, Mr. Hoover, you didn't file your objections under 5.111B or C. I haven't seen that. Just be cognizant in raising that with the courts. All right, ex partes. Don't do them. I love that Santa Clara County over the last couple of decades is taking more of the Bay Area approach of like, no, I'm not even giving you a hearing date. Try again. I love Judge Pritchard's stamp that he's got under Family Code Section 3064 regarding custody and timeshare. So what do we often see with ex partes? We see vacation for kids. For one custody side, we see vacation, we see travel, we see choice of school, we see choice of doctor. No. You're not going to be rewarded with that, and you get a bad reputation in doing that. What we're looking at under Family Code Section 3064 is imminent or immediate harm to the child. Now, every parent feels that that's harm to the child. It's your job, our job, to educate our clients. That is, you validate their concerns and their feelings on it. But that's not immediate. That's not an ex parte. No reason to do it. We're really looking at physical harm to the child. Yes, overt mental harm, but there's no litmus test per se on that. And of course, taking the child, the code section says taking the child out of California. I feel like I know that's an ATRO violation, but I think it's more about the possible kidnapping per se. But be very careful about your ex parte requests. They're denied, rightfully so, more than they're granted. Moving then on to the issue of financial relief on ex partes. Again, don't do it. Your client feels that spousal support, child support, need for fees, etc. is extraordinarily important. It is, but not ex parte. Not at all. We're looking at immediate irreparable loss. So let's say if it's someone from a country of a different origin and they're able to remove $1 million and we're not going to have a plausible, a real concrete ability to get that $1 million back from a foreign state, a foreign country, yes, but otherwise don't do it because it's not actually an emergency for the courts. The courts are extraordinarily busy and don't have time for it. Yes.
We're busy. The courts are busy, but also it is line jumping. You've just said that it takes 2.5 months to get on calendar. There are people who do it in the normal course of business, and every time an ex parte is granted, it takes a space from someone else who was doing it in the normal course of business. So a lot of judges also consider that particular issue in addition to everything else when they're thinking about granting an order shortening time.
Yes, and I should be careful with if there's judges on this that it's not black and white 2.5 months, but I wouldn't be surprised.
It's a long time, whatever the time is, even if it's 6 weeks, even if it's 4 weeks. There are people who have done it the correct way. They're waiting their turn, regardless of the amount of time. That's right. That's right.
I feel we have a duty as attorneys, family law attorneys, in our education, advocacy, and acting in our clients' best interests to explain to them what's going on in the judiciary. That issue regarding choice of doctor is extraordinarily important to my client. Absolutely, it should be. And I should explain to her why those who have waited in line regarding very important issues, they come first. We have a budget resource crisis at the courthouse, one could say. And so it's part of our role and as counsel is to educate our clients, and it's that bedside manner that I think is very important to have. Okay. We've talked. I can spend a long time about client meetings regarding expectations. I think I did a bit about that. Meet and confer with counsel. Do it often, even if you don't like them. I just watched a judge recently say, yes, you met and conferred via a letter. That's not enough. Did you pick up the phone? Did you have a conversation? Did you meet, etc.? And I appreciated hearing that. So of course, if there's DV under California Rules Court, you don't do that. exchange all the documents and information prior to a hearing that you're going to be using under the CRC. Of course, impeachment, you don't have to. But BJ brought up a great point prior to the start with AI and AI produced documents, what's going to be happening in the future. That's for another seminar. Let's talk about, we talked about, oh, the evidentiary hearing. I mentioned that briefly with respect to, do you want an evidentiary hearing or do you want to rest on the pleadings? How much time do you have? Read the room. Does it appear the judge is ruling in your favor or not? Read your case, project where your case is going to be in the next 6 months. How badly do you need this for your client now? Either your affirmative request or your defense. How much can you wait later? And by the way, you shouldn't be doing that at counsel's table. You should be even doing that beforehand, the morning of, the couple of days before. You're only going to get half an hour, likely time-wise. You're probably going to get less than that. Assume you're going to get less than that. So make sure that you foresee, how do I approach this? If I did a 217 notice and I've got my forensic experts who are going to appear and they're going to testify and we're going to win at the initial hearing on support, nope, that's not happening. So what kind of Band-Aid can you put on this that's not going to hurt either party? Another approach is, how would a court look at this? A court of equity. Argue proposals as to what a judge is looking at, how a judge would look at the matter. Don't argue just polarity here and ask for everything. Court reporters, we got the new case that came out, which is great, but I don't think it applies to us per se. But court reporters, it is great. There is no court reporter. The courts can. This is now I'm in trouble because judges nodding up and down like I read it. No, I just read a blurb about it. But at least I read the blurb about it. I think the courts can.
Actually, everyone should read the case. It's really a wonderful discussion of disparity within the court system. It's a wonderful policy statement.
Right. So I don't think it's for everyone. And so for those, I think they have to request it per se, but I could be wrong on that. We do have our own court reporters. We do rely on it about 25% of the time, which is enough time. Client appearances, yes, we always want our clients there. I'm going to turn it over to Luca now because I've been doing way too much talking. Surprise. Because I really want to hear from Luca on these issues and then focus on each individual subject matter and how do we address it in Law in Motion.
So going on the is my client going to show up to court idea, always helpful to have, very tough to win cases without them. Remote appearances kind of changed that. But in the old days before COVID, there wasn't really a remote appearance option. The best Santa Clara County could give you was a rinky-dink phone line that sometimes worked and sometimes didn't, and that nobody really relied on. But now that remote appearances are kind of mainstream, I see it as a tactical disadvantage appearing remotely, both on the attorney's side or the client side for a Law in Motion matter. It's if you can get court permission, it puts potentially you and your client in different places, unable to communicate quickly about things that may change or develop over the course of a meet and confer effort or even a hearing inside of court. There are circumstances where remote appearances are appropriate. So, for example, if you have a client that lives in a different state or a different country, chances are they're probably not going to want to make the trek all the way out to Santa Clara County to appear in person. Sometimes you may have individuals with health issues, ill and can't come to court, long-term chronic condition, can't come to court. You know, in those specific types of circumstances, a remote appearance may be a good idea. We have a procedure for an application and a proposed order to be submitted to your judicial officer to ask permission. Can this party appear remotely? What I've seen in some requests that my colleagues have done is they just kind of check some boxes on the form and send it in. There needs to be a reason why your client cannot attend court in person. So put it in there. That doesn't have to be anything terribly long. But you need to give your fact finders some idea of why you're making this request. Can't just say a client wants to stay home in their pajamas, doesn't want to have to get dressed up. That's probably not going to work. But put something in there so your fact finder knows what you're asking for and why. Once we've figured out who is going to this wonderful Law in Motion court appearance that you filed for, the next question you have to think about is, Who's the judge hearing it? What do I know about this judge? Do I want to keep this judge on the case? Do I have a duty to advise my client about Code of Civil Procedure 170.6? I think the answer is yes. I have very, very sparingly used that preemptory challenge in my cases. I think it's subject to abuse, and I advise my clients about it. But generally speaking, I praise all the judges that we have on our bench, and say there's no reason to remove a judge unless you seriously have cause or believe that there is a serious bias. But it is something I think you have a duty to explain to your clients, tell them how it works, tell them what their options are, and then give your recommendation. What do you do? Once you get into court and you are now with your judge, what is the one thing you should really be focused on? Getting evidence in, get it on the record, make your arguments. If the court wants you to mark exhibits, if you want to reference exhibits. I think the one mistake that, younger attorneys maybe make a little bit, and even some older attorneys, is they get into court and they want to repeat what they already put in their paperwork. That's not a really good use of the court's time. You may sound great doing it, but your fact finder is off in la la land because he or she says, I read all this. I know what you're telling me. Tell me something different. Or if you don't have anything different to tell me, just submit. That's perfectly fine. A lot of lawyers feel like when they get into court, they have to talk about something, even though in some cases, maybe you don't really need to say a whole lot to your fact finder to get what the outcome you're looking for. Um, when you are preparing for and attending a law and motion matter, I think it's very important to review Jim Hoover's favorite Santa Clara County Bar Association rule. It is Rule 15. Essentially says that your conduct as a lawyer should project a positive image on the, see, look, he has it.
Yeah.
Positive image on the
I keep it
profession.
here at all times.
Exactly. And you should show respect for your judicial officer. Doesn't mean you always have to agree with them, but if you're going to disagree with them, do it in a respectful way. Law and motion matters have the potential to become unwieldy in some cases. There are a lot of emotions that are running high. You're going to have a client potentially who is not happy, angry, upset, scared, you name it. And it is part of your job as a family law attorney to kind of help them through that process beyond just getting the paperwork on file and arguing your points to the judge. It is difficult to do, but it is something that I think makes a well-rounded lawyer if you can manage a law and motion matter so it doesn't become a disaster. We're going to talk about some specific law and motion matters. We're going to do a little trade-off here and there. I'm going to start with the temporary domestic violence restraining order. Once that is filed, you will get a law and motion hearing date. With rare exceptions, you're generally not going to have an evidentiary hearing on your first hearing date to either prove up the claims of domestic violence or not. What is more likely to happen is that first court date will be a springboard of sorts to figure out, number one, where are we going next? Is this going to be set for a long cause hearing? Is this going to be set for a status conference? Is there a criminal case that may operate to delay setting this for an evidentiary hearing? Those types of questions will get answered either with another return court date, maybe a status conference if you're going to work on some settlement, maybe a long cause if that's not possible. But when that new date is picked, most likely someone's going to want to change the terms of your temporary restraining order pending that next court date. We often have to deal with issues like child visitation. Should the restrained party have contact with his or her children? If so, should there be conditions on that contact? Is there a need for interim orders for spousal and child support, which I'll talk about in a minute, but that's something that often comes up as a package of the restraining order paperwork, a request for support. Those are kind of the things that you're going to look at in a first hearing on a temporary domestic violence restraining order. I'm going to turn it over to Jim. He's got some pearls about custody and visitation, some other aspects of law and motion matters.
Thanks, Dave. Judge, any questions for Dave?
No, he was perfect. Thank you. Now we come to you.
Sure. I agree with you, Dave, regarding the restraining order request. Unfortunately, whether it's confirmation or recency or selection bias, we have a lot of those in Santa Clara County. The most important thing for me is education. education with our clients regarding, well, at the hearing, if there's no children, I'm not terribly concerned so much because very little is going to happen. I usually do not want to actually have the hearing that date. I want to buy some cooling off period in the litigation so we can do any type of due diligence that needs to happen and make sure that the immediate financial status quo is being met. If there are children, that should be first and foremost number one issue to address. When I represent the responding party or the restrained party, I'm not looking at the first hearing. I'm looking at the third hearing or the fourth hearing and making sure that my client is rehabilitating him or herself based upon the allegations or the reality of their alleged unfitness as a parent. Which then, of course, makes me I'll move right into custody and timeshare. Custody and timeshare is so important at Santa Clara County Superior Courts. It had its own track, and that's Local Rule 2. Education to me is so important before we move into law in motion. When I meet with my clients, I go through, like I said, the 12 points. I actually have it. I was drafting it with my colleagues at our firm just yesterday and today, and it's right here. What I do is I walk them through the process. And I look at, well, not the first hearing. I'm looking at, we're at the 6th or 7th hearing, and mom and dad aren't getting it. And so what I want to do is I want to address that right away. And it will be in my pleadings as well. What do I mean by that? Well, in law in motion, in the issue of custody and timeshare, legal custody, physical custody, and timeshare, and also services for the parents and the children, if it's a dispute, if it's coming to us, if it's coming to the courts, it's typically one of two or three things. One parent is alleging that the other is unfit, whether it's because of domestic violence or substance abuse or never changed a diaper, in any level of that. And the accused parent feels that accusing parent is a restrictive gatekeeper, an alienator, an undue influencer. So one side's levying these charges that the other parent's unfit because of domestic violence, substance use, suicidal ideations, whatnot. And the other parent's saying, that's not true. More importantly, you're alienating the child from me, so to speak. Or you can have all sorts of those allegations on both sides. So rather than taking an approach of anti-parent, I take an approach that is child-focused, that's child-centric, and child-forward. Because that's what the judge wants. More importantly, that's what's best for your kid. That's what's best for your child. So I have my clients educate themselves. The first thing I have them do is read the 100 things that parents should read about in developing a parenting plan. Number two, I have them review the entire judicial counsel form. I have it in one document, all custody and timeshare orders. Because they're like, I didn't even think about Halloween. Well, good. Hopefully you don't have to. But nonetheless, it's there for you to think about. Then I actually give them a link to go through the rules of through Family Court Services and the local rules. Not at the sacrifice of my own education, but a lot of clients are savvy these days, and I want them to go through that. Then I want them to look. I have links to the top 5 books for co-parenting: Biff, Mom's House, Dad's House, etc. And I said, choose 1 or 2, but it's good for your child to do this. Whatever number I'm on, this is what I do in court often. I don't know what number I'm on. Next in order is all the classes, co-parenting classes, not TV related, just co-parenting classes. Family Court Services has a list, sponsored. They don't call it sponsored, but it's a list. And if there is DV, I'll have my client work with some of the conflicts and accountability classes. I'll have my client work with a custody coach, typically one who was at Family Court Services. Someone who worked at Family Court Services and then retired from Family Court Services and has his or her private practice. This is a person who will review all the pleadings and work with my client, not me. This individual will do so. I'll have my client sign up for our talking parents or a family wizard. I'll have my client reach out to their parent to work with perhaps co-parent counselors, perhaps, all these things. And there's more to all of that. Now that's a fire hose, and that's not just a one button to press. Yes, Judge.
So Jim, to put a bow on that, can you relate it back to how all of those suggestions
Yes.
help you in a law and motion practice in front of the judge? What do
Because
you
I'm,
do with all of that?
yes, because I tell the judge, Your Honor, I understand that I got arrested for a DUI. I'm innocent until proven guilty, and here are all the things that I am doing to address it. 100%. Not that, well, she made me have the first drink. I'm focusing on my two children. I'm focusing on myself. Here are all things I'm doing. We know ultimately through an emergency screen or otherwise, these are going to be the recommendations by a mental health professional. Get it out of the way now. Demonstrate to the court in your request for order, in your law in motion, that you're child focused, friendly, forward, centric, that you're offering solutions that are best interest of your child. What are the two main presumptions that exist? Frequent and continuing contact. The parents know best for their children. And so it's important that you're focusing on your child in doing so. Same if you're the accusing the other side of a DUI. Is that I'm not just doing this because he got a DUI, Your Honor. I'm showing the nexus and the concern I have here between his DUI and the children's best interests. It's not just DUI and that's it. And I'm focusing on the children and what's best for them. So you put a lot of that in your 10 pages. And what's important there, and we've seen this, because it's not just one custody hearing, it's quite a few. There's a theme that exists. And my clients, I have heard from the judges, they'll say, I'm seeing consistency with with father, that he is truly focusing on children's best interests here. He's not perfect, but he's focusing on children's best interests. And number one, it's best for the kids. There's a lot more I can go into on that. Of course, there's the family mediation, 3170, 75, local rule 2A and 2B. Get that out, not out of the way. That's my internal voice. Sorry, everyone. Have a robust mediation and make sure you do that early. So when you have the first hearing, you can actually accomplish some orders. You will get orders even if there are none at the first hearing, if there are none. So that's probably something for the practicum we can talk about. All right, Dave, back to you.
So one of the law in motion issues that you're going to deal with frequently is interim or temporary child support and spousal support. Before we get into all the little nits and things you need to know, please buy a copy of Xspouse and go to their website or whatever software your county approves and uses. You need to use the same software that your court's going to use, your fact finder is going to use. It makes things infinitely easier. We happen to be an ex-spouse centric county. Go and watch their YouTube videos. I know it sounds corny, but they don't have an instruction manual. If you want to learn about ex-spouse and all the inputs, go watch the YouTube videos. They're incredibly helpful. It'll make you a better lawyer when it comes to actually putting the numbers into calculation. One of the first things you want to learn and advocate for is your retroactivity rules. I filed a motion for support. Well, when does it start? Family Code Section 4009 says child support can be made retroactive to the date the first pleading or petition or paper was filed with the court, which is normally a petition for divorce. Could be a paternity petition, could be a standalone custody proceeding. Whatever that first piece of paper is, that's your outermost date for retroactivity for child support. One of Jim's favorite cases on spousal support, Marriage of Dick, says you can also ask for spousal support all the way retroactive to when your first piece of paper was filed. Very important to know those rules, very important to know how they will come into play in your case. Once you determine the retroactive date of spousal or child support, the next date you got to figure out is, well, when is my commencement date? When are these payments actually going to be made to my client? It's an important thing to have as part of your presentation to the court. When you're thinking about commencement dates, you should also be thinking about arrears. If my retroactive date is January 1st, but my commencement date is May 1st, well, that gives us 4 months of arrears. We have to do something with them. Set a payment plan on them. Usually the easiest way to do it. Some people like to do a lump sum, but it should be something you incorporate into your presentation, either through your meet and confer efforts or with your fact finder. Both the commencement and the retroactive date. You'll need to have both dates in order to have a legitimate support order. Once you figure out what your base spousal and or child support will be, you should at least consider whether there should be a Smith-Ostler order. something you can ask your fact finder to order to capture income above a support payor or payee's base salary. A lot of times, what I see people getting into trouble into is when a obligor or obligee has income associated with the vesting of restricted stock units, equity compensation. It shows up on a pay stub as income. It looks like income. It gets categorized as income by the Internal Revenue Service. But here's the one thing you need to watch out for. If the recipient of a restricted stock unit is going to be asked to pay Smith-Ostler support on the amount of money that shows up on his or her pay stub when it vests, you need to make sure that that same restricted stock unit is not community property. Otherwise, we have a double dipping issue. We can't have an obligor paying a percentage of income associated with the vesting of a restricted stock unit only to then have to divide that same restricted stock unit equally in the community property division part of the case. So something you need to be on the lookout for. You can reserve it, say, look, we'll deal with Smith-Ostler and our issues down the road. You can just have them characterized by an outside accountant to figure out what is community or separate property, but something you should always be on the lookout for. In certain cases where you're asking the court for spousal or child support orders, one person might not be working. You have remedies available to you. You can ask the court for a standard seek work order requiring that person to make applications to try and get a job. If that doesn't pan out, you can then ask the court potentially for an imputation of income, meaning you're asking the court to prepare a support calculation using an assumed income rate for one of the litigants to a case, even though they might not be earning that. That's something you should always talk to your clients about. Imputations of income or requests for them are quite common. Everybody thinks that the other party should be making more, earning more, or working more, one of the three. And that's how you would accomplish that result in the law in motion matters through the imputation of income. You can also ask for a vocational evaluation, generally reserved for spousal support proceedings, but I have seen judges bend the rules a bit and say it's child support, but I still want to have a vocational evaluation. If that's something that you intend to ask for, identify your provider first, figure out who it's going to be. Don't wait till the last minute. Have someone that's ready, available, and willing to take the case. Then you make your pitch under 4331 of the Family Code to say, hey, I think this person needs to undergo a vocational evaluation. After you get through all of that fun stuff, your law in motion matter is over. And it's so sad till you get to go back to court. But you're not done working just quite yet, just because you prepared everything, filed everything, went to court, argued, got court orders. If you stop then, you messed up. Findings in order after hearings. I have seen countless counsel who wait and wait and wait to draft the order. Don't be them. Just do it when you get back to the office or the next day when it's still fresh in your head. If you don't have a court reporter, your memory is going to fade of what the judge ordered. It's going to become a disagreement with the other side about what the judge did or didn't say or didn't order. Just get it done when you can. The rule of court is 5.125. It mandates that the order be prepared within, I think, 20 days of the hearing. Don't wait that long. Just get it out the door so you can move on to the next one. And then kind of the wraparound service is, hey, when you finish something that's a big experience for your client, have a debrief. Okay, this is what we just accomplished. This is our strategy. This is our game plan of what we're going to do next to get you to the finish line, whatever that may be. A lot of times clients leave court and it happened very fast. They don't remember what was said, or they don't remember what the court ordered, or they don't understand what just happened in that 20-minute whirlwind presentation that Jim Hoover gave. Sit them down, talk to them about it, explain it to them, go over things, go over questions. Otherwise, you're going to have a client that walks out of your office and goes, I don't know if that was good or bad, which is never what you want to have happen. I think we're getting close on time, and I wanted to reserve some time for questions. Judge, did you have something?
We have two questions. One is for me, and then I'm going to give the other to both of you. So the first is, if there is a lot of hearsay in a party's declaration or in their exhibits, how is it best for the other party to deal with this at the first hearing? If the attorneys offer to submit on the pleadings, then this seems to let it all in as evidence. So for me as a judicial officer, if both sides agree we're going to submit, but Your Honor, I'd like to be heard on some objections to hearsay, perfectly fine for me at the hearing. I also think if there is a lot of hearsay, like really like bad hearsay, I would call it, not, it's damaging hearsay that really does implicate, for example, Sanchez or that kind of thing. Maybe that is the time, Jim, as you said, it's not the normal course, but maybe that is the time to do a written objections. All right. So it really depends on how heavy the hearsay is and how much it prejudices, I think, one or both parties. The next question, please, is for one or both of you, which is, do you necessarily need to go through the seek work order request before the request for imputation of income, even if you're asking for only minimum wage?
So I'll take a stab at that. I think that's a very good distinction. Most fact finders will agree that a seek work order is not necessary for a minimum wage imputation, assuming that the candidate is otherwise healthy, right? Can work physically, mentally work a minimum wage job. So yeah, I would think that's not necessary. Most times you have folks who want an imputation that's a little higher than minimum wage. That's where I think the seek work order has to come into play, or the vocational evaluation.
I love County of Merced because they have a local rule that it shifts the burden that minimum wage will be imputed upon a non-working party unless they can show good cause. Why not? At least that was the case a few years ago. But I do agree with you, Dave and Judge, with respect to the lack of need. There's also that case, and now I'm on blast, not recalling the name, where you can go through all the want ads and you can provide it to the court, and that's not hearsay itself. If there aren't any other questions, I'd like to add one or two comments to Dave's.
Please.
Sure.
I don't have any open questions right now.
Great. On support, I could come to the practicum because there's so much more I want to talk to about spousal support. I am irrational when it comes to how much I advocate for my client at the initial support hearing, because those operative orders often remain in the case for a while. So you want ones that's most to your advantage, to your client's advantage. A couple of things. With respect to the issue of support arrears, I often will look at and do the tests of like, well, can we just reserve it? Whether I'm the obligor or obligee, can we just reserve that issue? It's what the judge is going to want us to do. Don't be that person, that attorney, at the chagrin of the judge and everyone in the courtroom, where you've got 6 different ex-spouses for each month when things change. No one wants that. No one ain't got time for that. None of us do. So it's like, just reserve it, or try to meet and confer with counsel quite a bit and say, this is, unless you have one of those cases where someone's being a, not the counsel, but the other side. It's one of those where, has the financial status quo been really been met? Now, the important thing with the ex-spouse is the question that judges often ask is, counsel, so why are we both have your own ex-spouses? Got it. Put husband or father, wife, or mother on either one. You present them to the courts. This often happens. All right, so tell me why we're off here and why we're off there. And the judge will just go line item by line item. And so have your primary source documents ready. Often there will be some difference between the court's ex-spouse and our ex-spouse. I call it the ex-spouse troll. It's like a troll that just has a little difference. I'm trying to get you guys to laugh here. It can be off by $50, $75, and you have no idea why. Luca, you know what I'm talking about, right? So, and then when it comes to Osler Smith on RSUs, I think Osler and Smith are a bit antiquated right now in the shifting of the prejudice, particularly in spouse whose RSUs is equity compensation often is greater than her or his base. And I feel that there should, for those who've worked with me, fortunately or unfortunately have seen, I've sometimes tried to shift that a bit to so that the obligee receives more than just income support based upon the base of the obligor, knowing that there's going to be that only thing that's variable is time, because RSUs are vest upon the metric of time. If the obligor is no longer working, then there should be a support modification anyway. And yes, we have the market that goes up and down, but not that much. There's more on that, but I know we're reaching conclusion. Come to the practicum. I'm looking forward to it.
May I talk a little bit about the practicum with everyone? So it'll be on Thursday evening. It'll start at 5:30. We are going to start as a roundtable, really, and discuss just general issues related to law in motion. We have, I call it kind of stump the chumps. You can ask these two any questions you want, and they will provide their best answer to them. I will be there, BJ will be there, and we have some other family law practitioners. Then we're going to break into smaller cohorts. And we're going to allow folks who wish to practice either presentation to look at strategy in terms of presentation. We have some hypotheticals for you. Very, very low pressure evening, but we would like to give everybody an opportunity just to try some new things out, perhaps, and to talk to folks who spend a lot of time in court on law in motion. BJ.
Yes, again, please sign up. There's limited space, so you need to sign up to register for the practicum through the Santa Clara County Bar. And I would love to thank Judge Zecker, Jim Hoover, David Luca, and please, I'd love to see you all there on Thursday night.
Yeah, Dave and Jim, thank you. Really, I cannot thank you enough for sharing your wisdom and gifts with everyone. Thank you. BJ, thank you. Stephanie, thank you. You do a lot for us.
Thank you so much.
I love you, Dave.
Love you too, Jimbo.
Oh boy. All right. I will see everyone on Thursday. All right. Thank you.
Right
See you
on. Take care.
Thursday.
Bye.